Good morning, everyone. Now we move on to constitutional law. Let's start first with the state power established theme. The Constitution presents the formal foundation of the state. In the Constitution, we find the claim of the state to sovereignty, and the Constitution will point towards the source of state power, wherever this is supposed to lie. So here we find the preamble of the United States Constitution. Here it says, "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, ordain the Constitution." So here we have the act through which the state is created, formally speaking, of course. When the Constitution was presented, probably you could say the state was already in existence as a political reality. But the legal creation of the state, here we have it, and we have an expression of what the state tries to achieve. Then that the state of the United States was, at least on design, aimed to establish tranquility, promote the general welfare, and secure liberty is something that would be expressed in the Constitution. Here's another one, Article 1 of the Italian Constitution. The Republic of Italy is democratic and it's founded upon labor. Sovereignty lies in the people, who must use it within the limits of the Constitution. Again, you get here this sort of call to what is the idea that the state is getting founded, and you get a call to where the authority of the state comes from and what are its limits. Possibly now the most technical of them all, the Article 1 of the Spanish Constitution. Spain constitutes itself as a social and democratic state under the rule of law that claims as its values liberty, justice, equality, and political pluralism. Sovereignty lies in the Spanish people, from whom the powers of the state emanate, and the form of the state is the parliamentary monarchy. It's important to say that sovereignty is a very central concept, but it's also one that's very difficult to define. Something that's interesting about sovereignty is that it is wide power. To be a sovereign, to have the rights and powers of sovereignty, does not mean that you have a right and power to some specific thing. It is a right to a wide and undefined range of actions, ranging from putting taxes to regulating how traffic goes on the street, to regulating what can be in the market, to defending the population against external threat, and so forth. So in this regard, sovereignty is quite similar to the right to property. In fact, probably the right to property and sovereignty are the only two rights in the whole corpus of the law that have this feature, this wideness, this lack of definition. A sovereign can do many unspecified things, just as an owner can do many unspecified things. And naturally, just as the right to ownership is limited by the public law, we're going to see that the right to sovereignty in the modern era, we consider that it's also limited. This is quite different from how sovereignty would be understood in the era of an absolute king, uh, Louis XIV. We consider that sovereignty comes from the people, and in saying so, then the use of sovereignty, the exercise of sovereignty, cannot exceed the bounds of what the people would allow the state to do, cannot be used against the people. And naturally later, when we discuss the theme of a state power constraint, we're going to see that the modern constitutionalism has created procedural and substantive bounds for sovereignty. The state, when it's founded through the Constitution, we see this claim to authority, this claim to sovereignty. But to claim sovereignty, to claim authority is not to have it. The formal claim of the Constitution must be backed up in fact, or otherwise it is doubtful and it has this possibility of disappearing. There is where you enter the reality, for example, of revolution, when the French Revolution took place or the Russian Revolution took place, the prior regime was not legally revoked. It was politically defeated. It was politically erased. Well, you could say technically the constitution of monarchical France is still in force. The constitution of Tsarist Russia is still in force. Well, technically it does not matter. Technically it's not enough at this point. The constitution must have a factual basis in reality. When a revolution happens, that simply gets lost. And then it's also the feature of what's called today failed states. A failed state is one in which the constitution on paper is still there. There has not been a revolution revoking the constitution, but the sovereignty and the authority of the state in the whole of the country or in parts of the country is not real. It's not really possible to expect the state to be the boss and to govern in either the whole of the country or in certain areas of the country. And then you could say the state has entered a sort of limbo. Now, of course, a completely failed state is something like Somalia, but I would like to present some more interesting example. There are areas of Mexico in which you could say that Mexico behaves as a failed state. There are areas in which the control of the cartels is so strong that it in practice displays the claims of the formal government. And then you could say you have entered this sort of twilight, this sort of limbo, where state authority is compromised. Now, a state power must be constrained, just as it's unreasonable to grant people a right to ownership that has no limitations. It is unreasonable to grant the state a sovereignty that has no limitations. People have a tendency to abuse power. Then to grant them unlimited power is just to open the door to unlimited abuse. The words of Madison serve to very well introduce this topic. Madison wrote, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in next place, oblige it to control itself." So sovereignty has been constrained by both procedural and substantive mechanisms. We're going to start with the procedural ones and present the substantive one later. First, we have the so-called functional division of powers, separation of powers of checks and balances. And I will say that the latter idea is an improvement on the former. Essentially, this is the idea that the power of the state gets divided at least into three parts. Typically, that is the legislature, the executive, and the judiciary. The person that makes the rules, the legislator, is not the same as the person that applies it, the executive, and that is not the same as the person who has to come to judgment about whether the whole operation has been correct, the judiciary. By keeping these powers separated, you avoid tyranny, you avoid arbitrariness, because you ensure that different judgments, different minds, different biases have to come together for the proper and full operation of the government. That is the basic idea of separation of powers. Americans improved this idea and took it to a higher level when they perfected it beyond the idea of separation into the idea of checks and balances. And now let's go back to Madison, who wrote about this topic. To say that powers are separated is simply to say that the legislature is one thing and that the executive is another. Checks and balances is to say that it's not only that they're separated, they counteract each other in such a way as to ensure equilibrium or balance. So Madison wrote, "It is equally evident that the members of each department should be as little dependent as possible on those of the others for the emoluments annexed to their offices." And that's so far separation of powers, but let's continue. "But the great security against a gradual concentration of the several powers in the same department consists in giving to those who administer each department the necessary constitutional means and personal motives to resist the encroachments of the others. The provision for defense must in this, as in all other cases, be made commensurate to the danger of attack. Here's the crucial part: ambition must be made to counteract ambition. So in a separation of powers models, essentially what you say is, on paper, the judge is different from the legislator is different from the executive. They all have their own sphere. The checks and balances model improves this by saying it's not just that they're separate, they're against each other. If we assume that people in power will have the typical human motive to become more powerful, that the rich have the motive to become richer, that people have a natural ambition, then the best way to counteract this ambition is not simply to put on paper that it has a limit, but to ensure that there are others with competing ambitions that will counteract my desire to be more powerful. So if the legislator wants to become tyrannical, he will not be able to do it because the executive and the judiciary also do not want to be eclipsed. They do not want to be diminished. If the judge wants to become tyrannical, if he wants to become more powerful, he will not be allowed to do it because that increase in power will come at the expense of the power of the executive or the power of the legislative that do not want to give in. So you have now, instead of a mere separation, an equilibrium. The brilliance of the Madisonian construction lies in its realism. So Madison does not assume that politicians will behave virtuously. And he also notes the difference between words and reality. So he noted immediately that if you put in the Constitution a requirement for people to behave virtuously, that would just be paper. That in order to design effective legal rules, these rules must connect in a reasonable manner to the real motives that real people have. One can see the brilliance of the Madisonian construction by constructing it with models that may desire to be superior, but ultimately fail precisely because of their lack of realism. So here I took an article from a constitution of a country that is extremely malfunctioning, and here we know its vision of separation of powers or functional division of powers. So here it says the following: national public power is divided into legislative, executive, judicial, citizen, and electoral. And there we see that they're trying to innovate in the three powers by making five powers, and in the citizen power and the electoral power. And then it says, each of the branches of public power has its own functions, but the organs charged with exercising the same shall cooperate with one another in attaining the ends of the state. Okay, so this is, you see, it's like a moral improvement on the Madisonian model, because the Madisonian model says, they will actually clash. They will clash because they will all seek their own ambition. The output will be stability. In this constitution, you have the requirement that they should cooperate, all work together to construct a better world. And that sounds much nicer and much more desirable on paper than the Madisonian model. But the reality of this state shows a very different picture. Reality is that people remain what they are. People remain ambitious, they remain selfish. And then if you just ask them to cooperate, you'll actually get nothing, and it will just be a word on paper. If you make an equilibrium model, by contrast, at least you get political stability and the limitation of political power. The country from which I took this article is Venezuela. And then we have territorial distribution of power. Not all countries have them, but for those that do, typically this is considered to be another great innovation, another important idea that makes government less tyrannical, less arbitrary, that does a good job in keeping the government in check. And territorial division of power in its full version, its more mature version, is essentially federalism, where you have a division between the powers of the federal government, let's say the United States, and the power of the states of California, Texas, New York, Florida. Their power is divided. There are certain things that Florida can do, and there are certain things that the US federal government can do, and they are not the same. And it's not possible to say that one is necessarily superior to the other, rather they have their own sphere. So for example, national defense, that is only something that the federal state can do. There can only be armies at the federal level. On the other hand, criminal law, deciding whether gambling should be legal or illegal, deciding the penalties for theft, whether to have, for example, in America, whether to have the death penalty or not. Criminal law and its operation, it's all domestic, it's all national. It all depends on the states of Florida, Texas, Massachusetts, and so forth. So this federal division of power, what it does is create different spheres of influence. I can win at Florida, but lose at the federal level. I can lose at the federal level, but win in Texas. And that essentially means that we have less possibility of becoming the complete dominator of the whole thing, right? For example, now you have a Republican president, but you might have a Republican president and on the other hand, a Democrat state government, and then they are able to resist or to have policies going in a different direction to a very significant extent. The idea that federalism is protective against tyranny is something that can also be illustrated a little bit more obliquely with a little bit more of generosity in the works of Madison. So Madison elaborated the danger of a faction, the danger of faction. What is a faction? He wrote, "By faction I understand a number of citizens, whether amounting to a majority or a minority of the whole, who are united and actuated by some common impulse of passion or of interest, adverse to the rights of other citizens or to the permanent and aggregate interest of the community." So essentially a faction is a political group, a group of people, and that can range between the socialists, the environmentalists, or even, why not, the formal political party, the Republican Party, the Democratic Party. That's all factions, just groups that aim to get power to serve their aims, serve their political projects. Then the Madisonian idea is that faction is natural. If you have freedom, you will have faction. Freedom and faction go together like air and fire. If you make people free, they will naturally want to use that freedom to achieve their political aims, to achieve their political visions, to validate their vision of the world, and to impose it on others. So as long as you have freedom, you're going to have faction. You cannot eliminate it, but you can control it. And one way that you can control it is by making the state complex and large as opposed to simple and strong and small. If the state is simple and small, you have one faction, the faction takes control of the power, and that's the end of the story. If the state is complex and large, by contrast, if faction manages to get, as I said, the state of California, it will not get the state of Utah, and it will not get the federal government. If faction manages to get the federal government, it might not get the state of Arizona, and the state of Arizona will be able to present opposition. And by making things complicated, by making the structure of government complicated, imagine it dividing into various compartments, so that if there's a fire in one compartment, the fire will not take absolutely everything. There will be other compartments unaffected by the fire, where people have the possibility of eventually stopping the fire and reconstructing. And then that's what's behind the idea of federalism being a means to control power. Besides these procedural constraints, we also find substantive constraints. So a procedural constraint, like separation of powers, checks and balances, federalism, does not tell us what the outcome has to be. It only tells us that in order to get an outcome, all these people have to participate and come together and be of the same mind. So that's what it means that it's procedural. It does not fix an outcome. And then by contrast to that, you have things like fundamental rights and the rule of law, which are not procedural, they are substantive. They fix outcomes. When I say, for example, that fundamental rights are also the limit of state power, I'm saying that the procedure is not enough, that even if there is a fine voting procedure and a fine deliberative procedure, but the outcome of that procedure is that, for example, a certain group of people must be excluded from public life, I would say that's not acceptable. That is discrimination, that is a breach to equality, or if we institute a tortuous penalty or a form of torture through a fair procedure, that still would not be acceptable. The idea is that the fundamental rights define a limit of state action on substantive terms. Even if there is a fine procedure, the state cannot trespass the fundamental rights of individuals and in that way violate their freedom, privacy, physical integrity, freedom of thought and conscience, speech, and so forth. We're going to go more in detail into the fundamental rights in the session of the course on human rights. Now, of course, the fundamental rights are powerful because they build upon the separation of powers and checks and balances. If you had a list of fundamental rights, but you did not have an independent judiciary, then of course it would be pointless because those would just be words on paper. The fundamental rights become powerful if there is an architecture behind them that guarantees that they will be taken seriously by whoever applies them and applied fairly and predictably. To conclude, let's say something brief about the third theme of the book, which is state power democratized. So after putting so much energy into constraining the state, we might end up unhappy. We might find that ultimately this was not the best course of action. Let's go back into Madison for one last time and think what is the ultimate effect of all his protections and provisions. We could say that the ultimate effect has first been stasis. So we have a government that is shackled. It's shackled procedurally by federalism and by the checks and balances. It cannot act. Every time it wants to act, it has to get so much agreement between so many political parties that in principle its power to act is severely curtailed. On top of that, we may find that essentially the Madisonian system is extremely conservative. A government that does not act is a government that allows the status quo, whatever it is, to stay in place. And that will benefit the people that have power now and serve to constrain the possibility of, let's say, the majority, the disempowered majority, of being their interest being tended to. In opposition to this, we may say a state power that is constrained may be good, but it's not good enough. We may want a state power that to be mobilized for the common good. We may want to empower the state to take action to serve the interests of the majority. And here I can contrast a little bit the spirit of the Madisonian stasis to the idea of democracy with a quote from Thomas Jefferson: "No society can make a perpetual constitution or even a perpetual law. The earth belongs always to the living generation." Now, the spirit of this is the final word is not the law. The final word is not the procedure. The final word is the will of the sovereign people. So the will of the sovereign people needs to be enabled. It needs to be heard. And now, of course, there's mechanisms for that. And the mechanisms, I must say, they're, especially now after Brexit, they're very unpopular. But the point is not to judge things on one specific case, but to judge them in their essence, right? And then you have mechanisms like a referendum, when people get to vote and decide on a particular issue, or for something that is especially needed in presidential systems, not so needed in your parliamentary systems, which is the vote of recall, by virtue of which you could say that you're no longer confident in one particular leader. And the idea would be that through these mechanisms, it becomes more than a state power constraint. A state power gets mobilized to serve the democratic interest, to serve the public interest. One way to make concrete the appeal of democratization, as opposed to the Madisonian stasis, would be by presenting a historical vignette, a historical anecdote from the era of the New Deal in the United States. So the New Deal, coming on the heels of the Great Depression, was a program of social welfare being led by FDR. When FDR tried to pass the New Deal, he was essentially opposed by the legal and political system that was operating, let's say, on a Madisonian spirit. Now, the leadership of FDR had to be constrained. It had to be fit within procedural boundaries, and it had to be fit under the fundamental rights and the rule of law. Fundamental rights that were interpreted in a way that was favorable to the status quo. So a little bit scandalously, what happened here was that FDR wanted to have, let's say, a minimum wage. He wanted to have labor protections and a lot of, let's say, welfare regulations that we come to consider natural in the modern welfare state. And the Supreme Court stood against him. The Supreme Court said, no, you cannot do that. And in jurisprudence such as the Lochner case, the Supreme Court said the federal government has no power to establish minimum wage, for example, because that would breach the freedom of contract of the workers. If, let's say, between consenting adults, so imagine that phrase, between consenting adults, we agree to work 16 hours at your bakery and to sleep in the cupboard, that would be okay. That is my fundamental right. I have a fundamental right to work 16 hours because that's my will. My will has to be respected and the state has no authority to intrude. And you see here naturally this judicial fallibility, the idea that judges would have to be the last word, is really put in question by cases like this. And essentially what happened, how the deadlock was broken was essentially by leadership, democratic leadership on part of FDR. And he behaved in a way that's quite tyrannical, essentially. He threatened the court. So in a way that would not, if by today's standard, when we hear something like this, we might actually think of something like Venezuela or Correa in Ecuador or the other famous populist and tyrannical governments. So FDR said, if the court does not change its mind, I'm going to put more judges in it. My friends, I'm going to put more judges favorable to me in the court. And then after a while, the court changed its mind. So the court, without saying that it was bullied by Roosevelt, the court said, oh, now we consider that actually our prior ideas were incorrect. Legally speaking, it is fine to have regulation on social welfare. But the moral of the story, of course, is that leadership had a role and that leadership, in this case, the leadership of FDR, which was populist and democratically validated, did not necessarily do wrong in overruling the Madisonian political stasis and pushing through, let's say, welfare legislation. So that we might come to disagree with this, but that is the argument on the other side. The argument on the other side is that the Madisonian model, with all its protections, has this deficit, which is the deficit in its power to achieve change, and that for that you need to tap into the democratic authority of the people. That we should not, so this, at least this is an example where the story came out positively, naturally. If you take more than the Madisonian side, you may say, well, that is an example where you played with fire and in the end you didn't get burned. But when you look at other scenarios, other countries, you can see that you can get quite seriously burned. So that is the story for now.